Hi, everyone. This is Kim Benjamin with the Benjamin Law Firm on the Kansas City side of Missouri, and we're here today to talk to you all about employment discrimination in Missouri, employees' rights. And I've got a guest from St. Louis today, John Ecker. John and I go way back. We, years and years ago, were criminal defense lawyers together, met specifically with DWI defense, and through the years, we've continued that area of practice, but we both independently got the bug. And the bug was to represent employees against employers, corporations, what have you, who discriminate against their employees. And for me, my experience was about 7 years ago, someone walked in my door, someone I actually knew walked in my door and felt that they had been discriminated against at work. Again, it was the AT&T retail store, literally across the street from my law office, John. I don't know if I ever told you that.
No, you didn't tell me that.
Literally across the street from my law office, walks out that door into my door, essentially, and says, help me, right? And then she brings 6 coworkers with her because she wasn't the only victim of the discrimination. And that started my journey to learn how to help employees who've been discriminated against. And it was December of 2019 when I took that case to jury trial in Cass County with a colleague here locally in the Kansas City area, Kevin Baldwin. And we tried that case to a Cass County jury over a 2-week period. It was a long trial.
That's a long trial.
It was, against 2 different law firms from St. Louis who came to our neck of the woods to try that case. And I got the biggest verdict in Cass County history for an employment discrimination case. Over $1 million on my very first jury trial, which is a big deal in our world as lawyers, to hit the $1 million verdict. And so anyway, that was how the bug bit me. And that's why I want to have this conversation today, because after that experience, I decided that the Benjamin Law Firm was not going to just be the Missouri DWI and Criminal Law Center. I'm also going to have under the umbrella of the Benjamin Law Firm employment discrimination and employee rights. And that's my specialty now, or at least my passion now, because I still do criminal and DWI defense. So John, I know you are very active in MACDL with me. You're now on the board of directors of MACDL, the Missouri Association of Criminal Defense Lawyers. You're involved in MATA, the Missouri, I can never remember the acronym for MATA. It's the Missouri
Association of Trial Attorneys.
Thank you. Which is the personal injury side of things. There's also NELA, which is the Employment Association for Lawyers. And then you were also very active in the National Trial Lawyers Association, correct?
Yeah, that's correct. And it was, now granted, I'm still just shy of 40. I'll be 40 in January. But a few years back, after having been a member of the National Trial Lawyers Top 40 Under 40 for a number of years, serving on the executive committee there, I was actually vice president for a year and stayed active with it. But despite still being under the age of 40, a handful of years back, they extended the invitation for me to join as one of the National Trial Lawyers Top 100.
Fantastic. Well, you and I are both very active in the legal associations, but our practices and our journeys are very similar in the sense that we started with criminal and DWI defense. We wanted to be in the courtroom. We wanted to be trial lawyers. Right, John?
Absolutely. Absolutely.
That's what we wanted to be. And then we both separately found our way to employment discrimination. How did you find your way there?
Well, there's a couple sides to it. First is, how did I start doing that? Because obviously, as we talked about, Kim, you know, I got my start doing almost exclusively DWI defense and lower level crimes. At the firm that I started with, we understood that there was an opportunity to help other people as well, not just criminal defendants. And so I was tasked with building the firm's civil plaintiff practice, which, as you know, is, you know, it could be auto accidents, slip and falls. That's what we think about and see on billboards. But there's a lot of other aspects of civil plaintiff work. And we had a woman come to our office. She didn't come to the office, she called. And she said, I think I'm being discriminated against at work. I think I was terminated as a result of complaining of the discrimination and what was going on, and having a work comp injury and things of that nature. And is there anything you can do to help? She said, and this is, you know, fast forwarding a little bit, she had called 20 or 30 other law firms She just had picked up the phone book and was calling. Nobody would take these types of cases. And Kim, you know this. There's so many attorneys that get a call and say, I've got an employment matter. Can you help me out? They don't know who to talk to. They don't know anything about it. And it puts us in a unique situation to be able to help people. Well, at the time, I didn't do those. I didn't know anything about it. But this woman, I felt bad for her. Had I declined that case, my first employment case, she said she would have closed the phone book and been done with it. And I was able to help her, and we went on a journey. And it's so funny, as you talked about how similar our journeys have been to get to this point, and you having such a great result in your first one. I had a similar experience. We ended up taking that case to trial based on sex discrimination and retaliation. And in the circuit court of the city of St. Louis, we ended up surprising, I think, a lot of people. My first jury, I'll tell you, most attorneys don't have stories like you or I, either of us.
I agree.
My very first civil trial, my very first employment case, $7.5 million. And it felt incredible. When that verdict came in, 300 compensatory, 7.2 million. The best part of that, and I'm being 100% genuine, was when my client turned to me, hugged me, cried, and just said, thank you for trusting in me and for giving me this opportunity. I still, to this day, and that was back in early 2014, I still Facebook and email and just occasionally call to check in, but check in with my client, because I think this is one of those things where we can also develop, in this area of law, we developed such a relationship. And once I got that bug, as you put it, holy cow, we have the opportunity. So in school, I was bullied at times. I think everyone goes through bullying at some point. In employment law, we have clients who, no matter what happens, it's a bullying situation. They don't have the power. No one's standing up for them. And a lot of times, and this is in certain case law, as you know, that the courts even recognize that companies are going to try to hide evidence. They're going to not disclose things, and they're going to try to blame the individual for everything. And I love, more than anything, that I get to fight the bully, and I get to beat that bully up in court, and I get to win for the person that got bullied. And that's what I really, really enjoy about this area of law.
I was telling a friend the other day that the reason I enjoy this area of law is very similar. It's that bully situation. I said, it's David versus Goliath for me. And I'm going up against this big corporation that thinks they can abuse and misuse their employees. And those are my kind of cases, my favorite kind of cases, because I'm literally prosecuting them.
Absolutely.
Under Missouri law, we are literally taking over for the attorney general and prosecuting a bad guy.
Yep.
A corporation for misusing and abusing employees.
Well, and you know what's great is we're doing that service not just for our client, but for our constituents, if you will, for the government. I mean, that's why we have fee shifting in these types of cases. Similarly, for civil rights cases, which we handle a lot of, and they're very similar as far as the prosecution of these cases. But that's what makes them very important, is that when you're successful, as you know, when you successfully prosecute that case, you've taken it out of the government's hands. You've worked tirelessly at this thing. You've put in a lot of time and effort and achieved a good result. That's why courts then award, even when you win, they say to the other side, yeah, we understand you just got a big judgment against you. You're also going to have to pay their attorney's fees. I know you paid yours, you pay this. You have to pay their attorney's fees too, because we really are helping take a load off the government. And regardless of anybody's view on the government or what's going on politically, and all of that ties into employment law and civil rights, I like that we're doing a service to, help our neighbors, really.
And that's the great thing about this area of law, is we're not just helping our client, we're actually helping every employee at that corporation and across the state and potentially across the country.
I still remember my closing argument, Kim, that I gave, my very first closing argument I've given closing arguments in criminal cases at that time, but obviously it was my first civil trial. And what I told them is, I said, I want you to come back with a number that is large enough that in California, New York, Chicago, anywhere in this country, that when some employer thinks about discriminating against someone or retaliating against them, they say, well, wait a second. You remember that jury in St. Louis, Missouri? And you remember what they did to their employer, who happened to be the St. Louis Metropolitan Police Department. And I think for what it's worth, I have not seen the actual number. What I was told was at that time, it was the second largest jury award against or in an employment case in Missouri history, and the largest jury award of any kind against a police department in Missouri history. I can't verify that, but I'll tell you this. The jury understood that they were the 12 most powerful people in the country that day, and they decided that we're going to protect Tanisha, who was my client, but we're also going to protect, hopefully, our sons, our daughters, and everyone else who might be subject to this, and we can make a difference. And that's the message I love sending with these types of cases. I have, as you know, Kim, I've got a 2-year-old daughter. She'll be 3 in a few days. And I feel like this is my mission, is that I'm going to make some changes so that she doesn't have to suffer things in employment that, as you know, everybody's experienced some things. Some of the things we see just blows your mind. And if I can make some changes, I'm protecting my daughter, I'm protecting other people's daughters, I'm protecting everybody. And that's what is really fun about what we do, is making a change.
I agree. And it's also why we do what we do with criminal law, to hopefully protect everyone and our constitutional rights in this country.
100%. And you know, I do civil rights as well, and we're not going to get into that today, but that's what's fun about these areas of law. It's why, you know, I think it's similar for you. I think we gravitate to where we feel like we can make a difference and what we enjoy. And boy, I'm not surprised, but I'm really glad that both of us ended up, you know, protecting employees, particularly since, I'm sure we'll talk about this a little bit, but holy cow, unfortunately, most people don't understand their rights and don't know what to do when they're in that situation, and feel like they can't protect their rights because they're just going to be bullied and fired. And so I love taking every opportunity that I can to try to help, you know, make sure people at least understand what their rights are and how best to, you know, to fight the bully, if you will.
Right. Well, let's start with educating the public in this video. Let's start with, all right, so I've had people call me that say, you know, my boss doesn't like me, they changed my hours, and, or, you know, whatever, they yelled at me, and, you know, we're an at-will state in Missouri. What that means is you can be fired or demoted or promoted without cause. You know, your employer can do those things to you, and they can be a bully. However, because of the Missouri Human Rights Act, there are certain things they cannot do. So let's talk about what are the things, if Joe Public is looking at this video and wants to know, what is the law in Missouri? Am I a protected class? Can my boss do this to me? Let's talk about who actually is protected in Missouri from that.
Great question.
Boss.
Great question. And before leading into that, you know, we recently we had some changes in the law. I say recently, but in the last few years. And so really the exclusive remedies for employees to bring a claim, and I'll tell you, we generally have 10 to 20 people call us each day. We have to have a staff just to manage those. We handle a lot of things, and most of the time we get, well, my boss is being mean to me, a hostile work environment because he's being mean or she's being mean. I don't get along with a coworker, this or that happened. As you talked about, it's an at-will employment state. And what that means is, like you said, an employer can hire or can fire, retaliate against, like I said, terminate someone for any reason or no reason at all. That's the general law. Then we have carved out exceptions that say, with that being the general law, however, it cannot be for these reasons. We have federal protections, and there are certain local protections as well. But at least just looking at Missouri, Missouri has 3 primary avenues to protect employees, okay? One is, as you mentioned, the Missouri Human Rights Act, which doesn't just even touch on employment situations. We've also had cases dealing with places of public accommodation, housing, things like that, where we've been able to bring the case under the Missouri Human Rights Act. We also, the second is going to be the relatively newly created Whistleblower Protection Act. That was, it used to be, Kim, that we could bring a lawsuit under a policy or a public policy exception that would say that, well, if the employer does something bad that violates public policy, then you can bring essentially a common law claim against them. The Whistleblower Protection Act was created, I think, to benefit employers by more strictly defining when those types of cases can be brought. And then the third situation is going to be a workers' comp retaliation claim, where an employer has suffered an injury on the job. They're getting ready to make a work comp claim. They could make a work comp claim. They do make a work comp claim, and the employer retaliates against them. And those are the three primary things that we look at. There are some federal protections, particularly start talking about FMLA, and we have the ADA, Title VII, things like that. But to jump back into it with the Missouri Human Rights Act and who does this really protect? Well, that's going to protect someone who's defined as a member of a protected class, okay? And we also, it's not just any employer, and we run into this problem sometimes. If there aren't enough employees, they may not be, your boss may not be an employer under the law. But with that said, if you're a member of a protected class, which would be, basically either sex, frankly, but sex, race, national origin, religion, age of 40 years or older, okay? Things of that nature. What's up?
Disability is another one.
Yeah, oh, absolutely. And that's almost an entirely different animal as far as how we handle those. And we'll talk about what, disability and how it pertains to things, because that's one where it crosses into workers' compensation, retaliation, and stuff like that. But with those, you're protected from being discriminated against because of your belonging to one of those classes, okay? Frankly, that applies to everybody.
It really can apply to a lot of people and a lot of different situations, but the difference is not only do you have to be a part of the protected class, you mentioned not every employer has to follow this law because of the size of their business. So let's apply that for the.
Yeah, so it depends, and this is where it gets murky. So some claims that someone might have, let's say that you are, you're the only female working at a business, you are talked down to, treated wrong, you're just treated differently than the men. For this scenario, you make a complaint to the company and say, I believe I'm being discriminated against based on my sex, based on being a female. I'd really like for this to stop. You would potentially have a lawsuit that you could bring or a claim that you can bring. There is something that, and I think we'll talk about this a little bit, there's a step that has to be taken before any lawsuit can be filed, and it's time sensitive.
Right.
And so that's why really with this, I love educating the public that if something like that's going on, you need to address it pretty quickly.
Right.
Okay. Under the Missouri Human Rights Act, to be defined as a quote unquote employer, the business has to have 6 or more employees. So if they only have 3 employees, they're not going to be subject to the Missouri Human Rights Act because they're not a quote unquote employer.
And most small businesses are going to have a small amount of employees, but if the owner is also an employee, then they count too. Yeah,
and there's a lot of different things going on. Before we jump back into, well, let me do this so I don't forget, Kim, because otherwise I will, you know me. At the same time, you may have a similar claim under Title VII of the Civil Rights Act of 1964, which is the federal protection for this type of activity. And in that same scenario, they define employer to be 15 or more employees. So I've got a few cases right now that are pending where we had to file with the Missouri Commission on Human Rights as opposed to the EEOC because the EEOC will not have jurisdiction because we have 7 or 8 employees, but we don't have the 15 or 20, which is required for an age discrimination case.
So under Missouri Human Rights Act, a Missouri employee could have a claim if there's 6 employees at the business, first of all.
Correct. Now, let's say that when at the time that you may have a claim, your business only has 4 or 5 people. I would say call a lawyer because there are ways to get creative and say, we're not just talking about at the time you were terminated. Let's say they had a little bit of turnover with a couple employees. Now we can try to use, within a close period of time, now we can use that to try to establish the 6 or more employees. And there may be avenues for relief once we get into it. I don't know how you do talking to new potential clients when someone calls in. We don't just listen to what someone tells us, hey, I think I may have a lawsuit because of this, or I think I'm being discriminated against because of this. We actually go through, takes 15, 20, 30 minutes. We go through and analyze everything. I can't tell you how many times, Kim, someone has called us and said, I think I have a claim because of this. I think my employer is doing something illegal. We find out that's probably not a very strong claim, but oh, guess what? You were working 50 hours a week. You were on salary, but you weren't actually having managerial responsibilities. You couldn't fire people, things like that. Well, maybe we don't have a good claim for this. And I have one of those cases right now, but now we have a wage and hour case that we can go after them for, even though they may not have enough employees for other types. So there are always different things. I wouldn't let the number of employees hold someone back when there's something being wrongfully done.
Right, for sure. If you feel something wrong is happening, reach out to a lawyer, and reach out to a good lawyer who's been doing this for a while like us, because you're going to potentially, like you said, find that this story isn't exactly a claim, but boy, something else is happening over here that is a claim.
Oh, and you know this, Kim, we fight for the little guy. We don't fight for the little girl. We don't fight for the big bully. And so when somebody comes to me, when they're being wronged, I'm going to work my butt off to see if I can figure out some way to try to right things that have been wrong. So those are the big things though to look for. If if you just have personality conflicts with your boss, or they're being mean to you, that's probably not going to give rise to, for example, such a hostile work environment that it's severe and pervasive to the extent that no reasonable person could be expected to stay in that job. But where we start to identify some of these protected classes or some other things that are going on, we have a lot of avenues for relief and can get creative. I don't know how you do them. I know there's a lot of attorneys out there who say, I'll meet with you if you give me some money, or I'll do this on a flat fee. And the way I do things, and it's not to say that that's wrong. I'm very picky on the cases that I take, and we vet them out very thoroughly, because I never want for somebody who I believe in, and I believe they've been wrong, I don't want them to end up behind the eight ball, if you will. I do all my cases on a contingency fee basis. So when I bet on that case, I'm full steam ahead.
And let's explain what that means, John, because for the average person, they think that they call us and they have to pay us for our advice. And in these kinds of cases, they don't have to.
That's a great question, Kim. I have had cases where individuals will review contracts or something on an hourly basis. But if we're going to get into, when I say a contingency fee, what that means for my practice is this. Someone calls us and they say, I believe I've been wronged, and we review the case and we decide that they might have a case there. And when I say that we believe in it, it's not to say that somebody comes to us and we are not able to be in a position to take that case, that we don't believe in it. When I represent these clients, we have a lot of time that we put into these things. Hundreds and hundreds, if not
time and money.
Yeah. Well, that's the thing. We have a lot of time, but we also have a ton of money. I take out of my pocket and I pay all those bills while the case is getting litigated. One of the most recent ones that I had, I think, are expenses, and it was just an employment case. We didn't have injuries or anything like that. I had $47,000 in that case. And that's something that I think is the only way that a lot of times people are able to pursue seeking justice. If you've been terminated, what are the odds you can afford $20,000 for a lawyer or $50,000 for a lawyer just to get through part of litigation, filing a lawsuit, taking a few depositions? And that's why I think for me, I feel that it's my obligation to help as many people as possible. And when I take these cases, I take them on a contingency fee basis. So when we move that case forward, whether we settle it or we get a final jury award in that case, at that point, per our arrangement, the money that came out of my pocket to go to court reporters, investigators, people who are sheriffs who are subpoenaing witnesses and things like that, that gets paid back to us to reimburse us. We don't actually get that money, it's just reimbursing it. And then we take a portion of whatever we recover for our client from the remaining amount. And that's what a contingency fee basis is. There is the ability, generally for attorneys, if they're unsuccessful, to go back to the client and ask for the money that they spent on their behalf. I don't do that. I've had cases that I've lost. I've lost money. It's not a great conversation to have when I go home to my wife and kids. Yeah, honey, I lost $20,000 today. But based on the success that we've had, that's very, very, very few and far between, maybe 2 cases in the last few years.
Well, and that's why we have to be so picky and vet the cases.
Exactly.
And sometimes we have to tell people no.
Yeah. And frankly, if I take a case and I lose it, I have never once in my career gone back to my client and asked for a penny. That was a risk I took. I believed in them. And we did the best that we could. And I beat myself more up on the fact that I was not able to get a recovery for my client than I am that I lost some money, fronting expenses for my client related to that litigation.
And this is a good part of the conversation for people watching to know that ask the lawyer you're talking to all these questions because you want to know how much you're responsible for out of pocket, win, lose, or draw in the case. And 2, read that contract.
Yeah, 100%. Well, here's the thing.
We have to have a contract with our clients.
100%. I walk through that contract with my client. I don't just say, here, sign it. We're good to go. Here's basically what it says. I walk through every single line because I want to make sure we're on the same page. If we're not, it can create some problems. Right. And I explain what things mean and things of that nature. The other thing that I'll add just with that, Kim, I do know of some attorneys who will take a fee just to talk to someone. And
consultation fee.
Exactly. There's nothing unethical about doing that.
Right.
It's something I don't choose to do because if somebody's going to come talk to me, it's very easy for me to say, look, I'm just not hearing anything. Go talk to another lawyer or something. But I'm not going to take money from people just to listen to them. So we're looking for cases, not just to take money from people for our time. And the other thing is that I think that it is beneficial when we take cases on a contingency fee basis because it means we believe in this case, we're betting on the case, we're going to fight it, as opposed to someone paying us hourly or paying us on a flat fee, because I think the attorney maybe loses some of the incentive to care what the result is if they don't benefit from it. I think that's where the defense side on these cases, there's some, most of the attorneys I deal with, fantastic on the defense side. But some of them, I think they just want to bill their client money and get to certain points and they lose the interest in what's actually happening with the case. When we do it on a contingency fee, person doesn't have to have a single penny to their name. And we're betting on this and we're fighting this with them. And that's why we really become a team. And I love that when I work with my clients.
Yeah, I agree. We're the same in my law firm too.
100%.
So let's talk a little bit more about what those protected classes.
Yes.
People have heard of sexual harassment in the workplace and hostile work environment. They've heard of they're being discriminated against based on their race or a disability. Let's talk a little more in depth about what those things are. Let's start with sexual harassment.
Okay. So sexual harassment, it's all too common still. We're hearing about it with the Me Too movement and everything. And shockingly, it just doesn't seem to change things very much. I have seen sexual harassment from all walks of life. So we're not just talking about man on woman.
Yep, I agree.
I've seen female on male. I've seen female on female. I've seen male on male. I've seen other gender identities. I've seen everything. And so anyone's protected from being sexually harassed. Sexual harassment is a little bit tougher to prove, at least from what the standards are. And we won't go into this. If you believe you're being sexually harassed, you need to talk to an attorney immediately to identify some things. But we have, and Kim, you know all this, but we have to show that it's severe or pervasive. We have to show that there's some kind of tangible employment action versus adverse employment action. Those are the things that I think might be a little nuanced to get into today. I think the bigger lesson from that is if you're being sexually harassed, that's wrong, and something needs to be done with it. Right. Before we move into some of the other types of claims that could be brought on for protected classes. It's important to point this out so that we don't forget. A company is only going to be bound by its potentially its policies, but the actions of its managers, supervisors, board members, HR members, things like that. And so where an individual is being sexually harassed by a coworker who is not a manager or supervisor, such as to bind the company by their actions, it's really important that that individual, aside from what I believe is contact a lawyer immediately, would be that this type of stuff, and this is true also for other protected classes where there's maybe racist comments being made or a disabled individual being made fun of. It's where it comes from a coworker, or even where it comes from a manager or supervisor, but particularly a coworker, there needs to be a complaint made to the proper avenue within the company, whether that's HR, to another manager or supervisor who's not doing it, something like that, in order to protect that individual. And I know people are very, and we'll talk about this, are very scared to do so.
Well, they're scared, rightfully so, because they are fearful of retaliation. They're fearful of being, blackballed, as we call it, or harassed for complaining. But the reality is, if they don't complain in writing, we recommend in writing.
Yep.
And we also recommend that you pay attention to policies and procedures of the business, because if there's a policy and a procedure in place, follow that procedure. If there's not one in place, then, at least complain up the food chain. Don't,
Right. Well, and I add this as well, and this is from doing, I couldn't tell you how many. We actually help individuals when they come to us and they say, well, I'm still employed there, but this is going on. We call it ghostwriting. We actually, free of charge to these people, if we think that there's something wrong going on there, we assist them in writing a complaint to make sure that the company is put on notice for that. One could say that it's to set the company up, and I say, absolutely not. I had somebody tell me that, well, you're just trying to set the company up. Heck no, I'm trying to make the situation better for my client and to get the discrimination or retaliation to stop. And guess what? If the company decides that they're going to retaliate as a result, then they were doing something wrong. They were always going to do something wrong, and they don't care about the law. And so a lot of times...
Nor do they care about their employees.
Oh, heck no. Heck no. But that's why it's important, especially even if you have coworker on coworker, that may not give a claim against the company, but it does create a situation where an individual needs to identify that and then make a written complaint, as you indicated. And I'll add one for you, Kim. We, in addition to help our clients do that, we don't get involved at that point, because we know that once a company learns that a lawyer's involved, they're going to start hiding things, and documents are going to disappear, things of that nature. Okay. We also recommend when our clients do that, that they send it from their personal email to a manager, supervisor, or HR, whatever is within the chain of command, as you indicated. And the reason is that if the company decides to terminate them, the individual is probably not going to have access to that complaint. Who knows what's going to happen to it? And it may take getting all the way into litigation before that gets produced by the other side, and we couldn't get it. So we have our clients send that from their personal email account, and that way it's documented. And even if they're retaliated against and are fired, and the company shuts down their work account and doesn't want to turn stuff over, we've got a handy dandy email establishing that they made a valid complaint or a good faith complaint of believed discrimination, and they suffered retaliation, which we would argue was motivated by that complaint. And that really strengthens a claim if one has to be brought. But when we do that, my goal is to help people out free of charge to try to improve their work situation, because that's all people want, really.
That's true. That's all they want. And what you mentioned about the email address is why we won't even ask for your work email address. We don't want to ever communicate with our clients on a work email address, because what people don't understand is the employer owns that address. You do not have any proprietary right to your email address at work. In fact, they can watch it. They can Big Brother you, so to speak. They can look at your monitor. They can have software on your monitor to know that you're on Facebook and not working. So never, ever communicate with your lawyer from work.
Right.
Or on a work email.
And it's not just a work account. It's and you kind of hit on it there, Kim. If I'm using an employer's property, being an employer's cell phone, an employer's computer, there's no expectation of privacy such that if an employer is watching your screen and you're sending personal emails to somebody that has nothing to do with work or to your attorney or anything, there's no expectation of privacy there. And so for an employer to monitor that, there's nothing, that there's likely nothing wrong with that. There could be caveats there, but just if you're using company property, they don't do anything personal on it, or understand that they may have access to that.
Well, when we started talking about sexual harassment, for just an understanding, a general understanding, let's talk a little bit about what is or is not. Like if a coworker is dirty jokes or showing dirty pictures on, oh, see what I found on Instagram. That's not necessarily sexual harassment, but it's worth talking to an employer or a lawyer about, like you said, to see if we can help that situation get better by helping you ghostwrite for you a complaint to your employer.
And make a complaint and hope that it stops. Kim, I will add this. My opinion for those scenarios and anything that some might say, well, it's trivial, that's what just happens in the workplace, that stuff happens. My opinion is that it is still sexual harassment. The question is whether it rises to the level of sexual harassment under the law. I want to be clear, we're not sweeping anything under the rug. It's just the law says that in order to be sexual harassment, it must be so severe or pervasive to affect the tangible conditions of one's employment, okay? The safest thing, because it is a high burden that we have to prove with that, is that when that occurs, a complaint needs to be made. And that's the best step for somebody who's facing that or any other type of discrimination. Jokes that are made, teasing someone because of their age and being slow and things like that. We have an uphill battle because our legislature has decided to continue to make it more difficult for employees and better for employers to make money. And so they keep making it tougher and tougher. The one thing that, in my opinion, as far as the discrimination that occurs, the one thing that I still find is about the strongest claim that we could possibly have relates to that retaliation aspect of it. And that's why it's important to go ahead and make that complaint. People need to know this. I think back to other jobs I had when I was younger, and if something like that was happening, I wouldn't want to rock the boat. I wouldn't want to make that complaint.
Right.
But the Missouri Human Rights Act says that if you do make that complaint, then the employer is prohibited by law from taking adverse action against you, which may not even include termination. It could be removing your responsibilities, giving you a pay cut, taking away your hours, things like that. Mm-hmm. That would be retaliation, and that's a lot easier to prove than the discrimination itself necessarily. So that's why I think it's really important that people take away, you're protected if you make a complaint. If you don't make the complaint, it might be more difficult for us to be able to help you.
Right. And so an example of a situation that is a discrimination. Let's talk about some examples of things we've seen in our practice that absolutely was discrimination, and we were able to help our clients, whether it be a file, get the settlement, or go to trial and have a verdict, or even other cases that we know of.
Just on the discrimination side?
Yes. I know retaliation too, all of it.
The retaliation too, but the retaliation doesn't even require, as we're talking about the Missouri Human Rights Act, it's a different ballgame than the Whistleblower Protection Act.
Right.
Retaliation does not even require actual discrimination under the law, but it requires if an individual to have a good faith belief that they're being discriminated against. Kim, that can be as simple as I'm a male. My coworker is a female, and my boss keeps giving me all the leads at a sales company, but doesn't give it to the female, and there's nothing there. Now, it could just be that I'm a great salesman, but and so there may not be actual discrimination based on sex. But if she makes that complaint to the employer, I can argue that that's a good faith belief. And the one thing is, I will not argue good faith belief to make a case. In my practice, I argue good faith belief because I believe it was there, but I also believe that my client believes that. I just don't take cases unless I believe that something illegal has occurred. Okay?
Right.
But if that's occurring, there may be, in that scenario, there could be discrimination, but there might not be, right? It's just, are those leads going to me as the male as opposed to female because of my sex as a male? Does that help explain discrimination a little bit?
A little bit. And I think that with age discrimination, for example, there are plenty of people out there who are being kind of pushed out or let go above the age of 40, and they really feel it's because I have hit this salary level and I'm costing my employer more money than the 21-year-old kid they can bring in. And that we're just seeing the older generation get let go. The employer has no loyalty to the older generation employee who's making good money and doing good work and has been loyal for 20 plus years. And we see this all the time. So that's another example of discrimination, that yes, the business might want to save money, but when they start letting people go solely because of their age.
Well, I'll give you just a few real world examples that I've seen in my own practice. Sexual harassment would be a supervisor or even a coworker, although that is not binding on the company necessarily, depending on what the employer, the manager, or supervisors knew. But I've seen individuals who have been sexually assaulted. I've seen individuals who they were sexually assaulted by a coworker, but the employer then turned around and tried to find some excuse to fire them because they didn't want to deal with a potential workplace liability.
Right, fire them.
Right, exactly. I'm currently handling cases where there are text messages where the manager or supervisor is just trying to flirt and feel out if maybe they could have some kind of sexual relationship with the individual, making jokes about things like that, sending group messages or group emails that are sexually harassing to some people. So we see that. I've had cases where individuals, unfortunately, I have one case south of here where we have a Black individual in a very white majority town. There were only 3 Black women working at that place. One of them complained because they were started to be treating differently, and then surprise, surprise, there were 3 terminations. I'll bet you can guess who those 3 were.
Wow.
Same kind of thing with regard to sex, women not being given the same opportunities. I've had those types of cases. Disability is a big one. Once someone has a work comp claim, they start getting treated differently if it shows that they were disabled under the law because of that, or maybe it's a long-standing disability that they've had or something that they just incurred, or even they may just be perceived as disabled by the employer. That is still a protected person under the Missouri Human Rights Act, even if they're not actually disabled, but they're perceived.
And give an example of what you mean. Would an example be an employee that comes to work and says, boss, I've just been diagnosed with cancer. I'm going to have to take off 1 day a week for chemotherapy, for example. Would they be a protected disabled class?
Potentially. It depends on whether or not, first of all, whether they're disabled, does that affect one of their, one or more, is it a physical or mental impairment that affects one or more of their major life activities or daily activities, okay? Now there are certain, and I won't get into it here, it's a laundry list, I'd have to go look it up and pull it up. But there are certain things that are defined by regulation and or federal law that say, we're not gonna have a fight over this one. This is a disability if you have this. What I'm talking about is that sometimes we'll have an individual who suffers an injury of some kind. Now, a short-term temporary injury may not rise to the level of being disabled, but if the employer, under the law, but if the employer perceives them to be disabled, then the individual can still not be discriminated against for being perceived to be disabled. I had a case getting ready to go to trial in Greene County, and then that thing got resolved, but that was going to be the issue, is that our client was claimed that having suffered a knee injury serving our country overseas, he said, I'm fine, I can do my job, but we believe that once he suffered a knee injury while helping move, he was working with a moving company, that the employer perceived that he was disabled because he had hurt his knee again and therefore let him go. And we brought that claim under perceived disability. There's a lot of moving parts here. I've seen everything. I've represented individuals. We're seeing a lot with COVID. and reduction in forces right now. And at a lot of companies, we're going to get it's called a reduction in force document that's going to show us for general layoffs, the individuals who are laid off and the individuals who are kept, their ages and their positions. And when we have something like that, it's a whole different story. We do severance negotiations for individuals on a contingency fee basis as well, only recovering if we're able to get more money than what offer is on the table to them originally. When we get those documents, and again, we're seeing more and more of them with layoffs due to COVID.
Right.
One of the first things we do there is if our client is between the ages of 40 and 70, such that they're a protected class, we start going through that document, and I'm a numbers nerd. You know that about me. Nerd in general, but numbers nerd as well. And I start going through and analyzing data and doing statistics to see if we're starting to see a trend of laying off older individuals and keeping younger individuals. And so we're always analyzing those as well. That's one, again, under federal law. It's a weird, screwy thing to fall under protections for federal law. To be an employer, your boss or your company has to have 20 or more, as opposed to the typical 15 for federal law protection for other classes.
Gotcha. Well, and so when we're talking to the public here and trying to educate them and say, if you feel you're being discriminated against, don't hesitate to ask a lawyer, because whether you think it's little or big, there may be something, there may not be. But we may be able to help you improve your work situation at a minimum.
And we tell a lot of people that, I know you do as well. I think it's really important to point out to people, sometimes they're afraid to even come to a lawyer.
Yeah.
Kim, you know all about this. Attorney-client privilege is the basis of what we do. So when someone comes to you or someone comes to us or goes to another attorney, presumptively, anything that someone shares with me, it goes nowhere. It is protected. I don't talk about any non-public case with my wife, with my friends, with other attorneys. I know there's a lot of shop talk with some attorneys. That's not how we do things. We have a staff here. That information is shared with our staff. But otherwise, if somebody comes to us, that information is protected. We're not going to tell the employer. We don't contact witnesses without that individual's permission. It's safe. So I hope that people understand they can come talk to a lawyer. They can do it for free, and it's protected. And I've had meetings with very high-profile individuals who come and meet with us, and they decide that they ultimately don't want to pursue anything with their employer, and so that's it. We decline the case. We hope that we were able to offer them some help, if nothing else, someone to talk to, and a little bit of information about how the law works. But I do sense from talking to people sometimes, they're afraid of even talking to a lawyer, but they need to understand it's privileged. It doesn't get shared. That's the basis of what we live by as attorneys.
Absolutely. And I agree that sometimes the person comes to us and they feel better just having shared their story.
There's a reason they call us counselors at law. And I take the counselor part very importantly. I spend, for me, Kim, I spend about a third of my time talking to my existing clients, because I think it's important for me in my practice to have a personal relationship with my clients and to communicate with them. So sometimes they'll talk to another attorney with my office or a staff member. I like talking to my clients personally. So I spend about a third of my day doing that, about a third of my day actually practicing law as far as appearing in court and prepping motions and preparing for depots and trials. I spend a third of my day talking to people who are not my client. They're not going to be my client. But that's kind of my giving back, if you will, to make sure people understand the law. They have someone to talk to. And that way, as things proceed forward for them, they can feel a little bit more at ease to at least understanding this crazy legal arena that we live in and take for granted, Kim. But that the public just doesn't understand these things. And I think it's important that they do and understand how to address some of these situations. I think you're doing a great service by sharing this information with people. That's fantastic.
Yes, I started several months ago, and I love giving this information to people, because it's not saying this is your case, this is your story, this is your answer. It's not giving legal advice. It's giving this information that so many people need, because access to justice in America is really not good right now.
That's right. That's right. Well, and so many people don't even know to talk to a lawyer. They don't think about it. And that's one of the best things anyone can ever do.
I agree. And talk to another thing that they can do, and I've had people do this before they come to me, is Google it, right?
Mm-hmm.
And they get to the Department of Labor website, whether it be the Missouri or the federal, and they get some answers there. Because frankly, the government does put out some decent information to help people understand.
There's like some great frequently asked questions. I know for the things that we do, you're right, whether it's state or federal. And sometimes I've seen, as we start looking through for local ordinances that might protect things, as we're starting to prepare a lawsuit to see if we have another claim related to a local ordinance. But even local governments provide some links to whether it's the Missouri Commission on Human Rights or it's the Department of Labor, like you indicated, state or federal. The EEOC has a lot of good information. It's good to do your research. Once you get that information, if it's not from a reliable source, or even if it is, it's worth talking to an attorney about. Some of that information is good. I'll be honest. When we come out of law school, Kim, I'm sure you may have been the same way. You come out thinking, well, the first thing I'm going to do is I'm going to go to one of these legal research sites and look to get an answer. My first starting point for a legal issue that I don't know off the top of my head, I go to Google. I just look for a reliable source, and then I hone in on what's going on. Google's a great resource. Just don't rely on things that are not, maybe you're from a different state or they're not from a reliable source. Use that as a starting point, and particularly when you're talking about the Department of Labor, the Commission on Human Rights, the EEOC, things like that. Those are great resources to just understanding, hey, does this sound like discrimination, or does this sound like something illegal? That might help people as well.
And do that Google search on your personal device.
That's right.
Don't do this on your work equipment. Even if you're home for COVID and you have the work laptop, don't do it at home on the work laptop. If it's 100%. Owned by the company, don't do this research on that device.
That's right.
Let's talk a little bit about the timeline of it all. Someone has a situation at work. They feel discriminated against.
Yep.
They come to a lawyer and they do a written complaint, as they're supposed to do, right? There are some other things that start happening that are triggered. And you had mentioned earlier, and this is where we'll talk about it, that there is a step, a required legal step that occurs prior to saying, I have a lawyer, I'm filing a lawsuit, let's go to trial, right? Before there's a civil lawsuit, there's this really significant legal issue in the middle, which does still involve us as lawyers helping our clients. Let's talk about what that step is.
Let's do that, but Kim, I want to add one thing, and this is just for how we handle cases, but let's move through just a couple of these pieces and just kind of set the timeline for what things look like as far as how we handle them, right? Perfect. Somebody's suffering discrimination, okay? It's important that they make a complaint early, clearly, and accessibly, okay? Because let's say that you're being discriminated against, Kim, and your employer plans to fire you. Let's say today is Friday, they're gonna fire you Monday, and it's gonna be discriminatory, okay? You probably don't wanna wait till Tuesday to make your complaint because you're already fired, and now it's not gonna be seen as retaliation. And it's not gonna be retaliation, or it may be more difficult to establish the retaliation. So the first step is that you have to make your complaint to the company very, very quickly. Now, if you don't make a complaint to the company, it doesn't mean that you haven't been discriminated against or you haven't been retaliated against. But my opinion is that that complaint should be made to help, in my view, give the opportunity to the company to right their wrong. And then it's their choice, okay? But we recommend that get done very quickly, because if they are going to fire you and it is going to be discriminatory or retaliatory, you want to make sure that you have that complaint into them, okay?
Right.
Once you're terminated, for example, okay, even before, so if somebody comes to us and they say, I got fired yesterday, all right, here's what was going on, this and that. We'll talk about the charge of discrimination, which is where you wanted to go. There's one step in the middle, and it's called a service letter request. So under Missouri law, when an individual suffers a separation from employment, whether they were terminated, resigned, whatever it may be, then as soon as reasonably possible, not to exceed 1 year, so it's basically within a reasonable period of time, not to exceed 1 year, an individual can send a letter to the company, provided that the company has 7 or more employees, and that they have been working there for 90 days or longer. they can request from the company that the company have a manager or supervisor sign a letter, send it back to them within 45 days of receipt of that letter, and tell us the true cause for the separation of employment. I do that before I do anything else when somebody's been terminated, because now the company is locked in and they can't start making up stories down the road to try to cover their butts. So if they say, well, we fired her for being late 4 times, well, that's it. They have nothing else to claim, because what the company is otherwise going to do if we get into litigation and filing these charges of discrimination is they're going to throw everything at the wall that they can and hope something sticks, and that they confuse a jury or confuse a judge as to what actually happens. So we help our clients prepare that. We send it. It actually comes from our client, not from us, because if we send it from ourselves as a law firm, they're going to hire their lawyer, and their lawyer is going to start trying to affect what that's going to be, and that's not the true cause. And that's what
just to explain to the public, essentially this is a letter that we help you write. We ghostwrite it for you. It comes from you, and it says, Mr. Boss, what are the reasons, all of the reasons why you let me go, fired me, laid me off, or whatever. And then they have to reply, according to the law, they have to reply within 45 days. And then that letter is, the 4 squares of that document
we can use it.
Stuck with. If they failed to say, oh, by the way, X, Y, and Z, they can't, they can bring it up later, but they look a little, it looks fishy, because they sure should have said it in that letter.
Kim, I'll go one step further. It looks a little more than fishy. We asked you to give us the true cause for the termination. Oh, now you have a lawyer, and now you're trying to claim something else was the true cause for termination. Now we have an employer who is lying, they're not honest, and we have to punish them. And I think juries love punishing employers. They're going to lie about stuff like that to try to cover their butt, to try to save money. And that's what it's all about for the employer. Now, with that said, they have 45 days to send a response. If they're a little bit late on that, let's say you get it 50 days later, you can't recover anything unless you actually suffer damages during those 5 days. That would be like you have a new job offer and they want to know what happened and you only have this 5-day window. Then we might be able to recover. I have had cases, Kim, I don't know if I told you about this. I've had cases, and I know for a fact there's one of the largest companies in the world, and I've sued them a few times, and they don't do service letters because they don't want to get themselves locked in. They'd rather deal with a service letter violation.
So they ignore the letter, okay.
They ignore the letter.
What's a service letter violation to the employer then?
As far as...
What does the employee get from that violation, essentially?
Right, so we file as part of our lawsuit, one of our counts or one of our allegations for how they violated our rights, we file a service letter violation, which says that we're entitled to our damages. Oftentimes when somebody's lost their job, they're trying to look for a new job, and boy, wouldn't it be nice to be able to show an employer they didn't do anything wrong. Regardless, we can be entitled in that scenario to punitive damages. So even if there are just very small damages as far as, well, it put my delay for looking for a new job on hold for a little bit because I didn't know what the company was going to say, right? Now you have some form of damages, whether it's emotional distress or whatever, as far as I didn't know what was going on. I couldn't get another job. I'm freaking out here. Once we have that, we can get awarded up to, possibly $500,000 as an example, as punitive damages for that service letter violation.
Well, and for the general public, what punitive damages are, it's punishment. It's basically punishment because it's slapping the hand, hopefully pretty severely, of the employer who's violating the law and not letting you know why you were let go. Because what you said, John, is right on the money. It is preventing, in certain situations, it's preventing them from moving forward with a new job because they don't know what their previous employer is going to say. It's on their resume. They have no choice but to put it on there. Chances are a phone call is going to happen, and they need to have some protection.
Yeah, I mean, and that's the biggest thing. Look, if the service letter, the real value of it is, do I put my previous employer on, on my resume, on my job applications or not? And it may not be that the employer or the employee even did anything wrong. It's just crap, they were discriminating against me or retaliating against me. I don't even know what they're going to say. Maybe they're just going to say something bad to my employer or, to a potential employer. I just at least want to know so I can get a job, what they're going to say so I can use that. So it absolutely affects people. Punitive damages, it punishes a company when they act in a manner of intent or reckless disregard to hurt somebody. And this big company, I'm telling you, that I've brought claims against for just this, it's because they intentionally do not do it, try to save money.
Have they admitted
to
that
avoid
in a
liability.
deposition?
I'm sorry?
Did they admit that in a deposition, that we're not going to respond to those letters to save money?
I have not yet gotten that in deposition. It's, as you know, we talk as lawyers throughout the country, those of us that do a lot of it. That's what we kind of know is the issue. I don't have a copy of that, but I'll tell you what, Kim, I got a lawsuit against them that I just filed 2 days ago. And we're going to get into that thing because they're denying liability. So we'll get into it. I'll be sure to ask that one just for you.
Thank you. I want to hear what answer, because they're damned if they do and damned if they don't.
100%.
All right, so let's talk about then the next step. We've gotten the letter back, or they refuse to give us that letter back, but there's another thing. There's a timeline issue, a very strict deadline for the next part of the process.
Now, I want to be clear, this is relating just to the discrimination and retaliation related to the Missouri Human Rights Act or the ADA or Title VII, right? Because Whistleblower Protection Act, work comp retaliation, FMLA, those are other issues. But just talking about if somebody's been discriminated against or retaliated against. The next step then, and understand this, you don't have to, I'm walking through kind of best practices and how my firm does it, but making a complaint to your employer is not required to do this. Right. Sending a service letter request is not required to do this, okay? But the next step would be that within 180 days here in Missouri, we want to file a charge of discrimination. The 180 days, we say that deadline, it's not necessarily just the termination date. So what I do is I talk to my clients and I say, when was the first instance of discrimination or retaliation? And that's what I base my 180-day deadline on. Because what the law says is we can only really go after trying to get compensation for things that occurred within 180 days preceding or filing of a charge of discrimination, okay? Now, Kim, you know this. There are ways to rope in things that happened before that, but we have to show a pattern and practice of that discrimination or retaliation, which I've done through other types of discrimination or retaliation against other people to try to bring that forward. With that said, general rule of thumb, you need to file a charge of discrimination in Missouri within 180 days of the discriminatory or retaliatory conduct, okay? Now, if that deadline is missed, there is a possibility to file within 300 days of the conduct with the federal government, okay, the EEOC, but you're going to be limited at that point to just federal recovery. And the judges, I love them to death. They're great. I love the federal process, but they're more likely to dismiss an employee's claim than a state judge would. And if we file in the 180 days, we can bring it in state court, and it's going to give us a better opportunity to get through discovering information and succeeding in getting to a jury. Now, and Kim, you know this, what I love about what translates is from doing DWIs, they're actually one of the more complicated types of criminal cases as far as all the moving parts and deadlines and things like that. That's employment. That's employment law. And so we have that going on. We can, once we file with the Missouri Commission on Human Rights, presumably within the 180 days, or we file with the the EEOC, it gets filed with both agencies at the same time automatically. Now, me personally, if I've got 15 or more employees for a company that I'm going after, what's weird is I file within my 180 days, and I file it with the EEOC, even though I have 300 days to file, and I intend to bring it under the Missouri Commission, the Missouri Human Rights Act. Have you seen that before?
I've not seen that before. Why do you do that?
Because the mediation process with the EEOC over here in St. Louis, and I've dealt with mediators throughout the state and frankly throughout the region. It's nothing against the Missouri Commission on Human Rights mediators, but I really have liked the experience that I've had with the EEOC mediators.
Is it a matter of they have more mediators because the feds have more money than the state?
I don't think that's it. I think that neither of them have a ton of money. I think that when I started out, we filed with the EEOC. I learned of the mediators there. Over here in St. Louis, and I also know throughout the state, we have a lot of attorneys with experience who will volunteer pro bono to help mediate these cases. But I like the mediation process with the EEOC, and I'm not as experienced with the mediators with the Commission on Human Rights. I file with the EEOC because whichever you file with, it's filed with the other one. It's just who's going to take the lead on this investigation.
Well, let's explain that, because two things. The public doesn't know, but what happens when you file a charge of discrimination, you outline all the details of how you were discriminated against or retaliated against because you complained of discrimination. Then they do an investigation, and you actually have a chance to mediate and resolve and settle the case at this level without ever filing a lawsuit. So that's what, when John's talking about mediation, that's what we're talking about.
Possibly. So let me explain this just a little bit more. And I'm sorry for taking up so much time, Kim. I'm sure.
No, that's okay. The public needs to know what it
charge of discrimination gets filed with either agency. Okay. An individual can do that on their own if they can't find an attorney. That's why it's important to know some of the deadlines. You can call them up, and then what they do is they send you a questionnaire. You complete that and send them any evidence that you have. And either the EEOC or MCHR, one of their representatives is going to help draft that charge for you and file. Okay. And then that kickstarts things. What we do is we draft that up, and instead of just a little one paragraph, I'm a member of this protected class. I think I've been discriminated against because of this. I think I've been retaliated against because of this. We actually just say see attached particulars. And I have 3 to 6 pages, single spaced, of all this evidence of discrimination and retaliation. And that leads into the mediation. Mediation, so what that process is, it's a way for parties to a potential legal claim to try to resolve their claim with the help of a neutral third party. And what that means is that with a mediation, I'm going to be in one room with my client. The company I'm suing is going to be in another room with their client. And there's going to be a neutral third party communicating between the two to help explain the law, explain their view of the facts, explain where people are as far as trying to reach a settlement. That's what a mediation is. Once that charge of discrimination is filed, typically, at least with the EEOC, they're going to contact the employer and ask the employer if they would agree to mediate. If the employer says yes, they're going to contact us as the employee. They're going to say, employers agree to mediate. Now, the mediators I work with, they know, hey, John, employers wants to mediate this thing. What are your dates? And I say, okay, well, we're going to do this. I have had cases where I say, go back and tell them they're paying 6 figures, or I'm not even wasting my time with this thing.
Right.
We have had mediations where that's when I knew we were going to have a decent mediation. But if both sides agree to it, then we get into that mediation process and we have an opportunity to try to resolve the claim. What I love about it, and this is where the government really serves us in this respect, to be able to resolve a claim early and potentially not have to go through the years and years of litigation, because Kim, you know this, you and I, we love litigation, but it's because we're not the parties. Right. So I enjoy it. I love trying cases, but I don't have to go through 3 years of people digging through my personal records and deposing me and telling me I'm a terrible person and doing it in public. So litigation's not fun. So it's a great opportunity that we get to have a mediation, and the federal government as well as the state government, we can find ourselves in that situation where both parties want to see if we can resolve this. They provide it to us for free, which if we have to have a mediation once we get into litigation, you know this, I've had a mediation bill for one day where it's $10,000.
Right.
We have to pay someone, and that's not guaranteeing it. Okay. So we have the opportunity to resolve it, but either way, here's what we know, Kim, is the next step. Within 6 months, we need to request a notice of right to sue, or one will be issued to us from the Commission on Human Rights, which is the state discrimination protection, or from the EEOC, which is the federal. we have to get that notice of right to sue as a prerequisite to actually file the lawsuit.
Right.
If you think about it this way, it's been several months and we've been terminated. We are make a complaint, we get terminated, we get our service letter, we file the charge of discrimination, then we have to wait a minimum of 6 months. For us to get a lawsuit filed, it's going to be probably more than a year after this thing even happened. And once we get that notice of right to sue, and this is where it's all complex, and it's the important part of making sure you talk to a lawyer instead of trying to do this alone. Once you get that notice of right to sue, you only have 90 days to file suit, and it still has to be, not just within that 90 days, it still has to be within an applicable statute of limitations from whatever conduct you're trying to seek recovery for. Kim, I know otherwise you'd jump in on this. Statute of limitations is that the law says if you're going to file a lawsuit, you have to do it within X period of time just to give the other side an opportunity to have some ending to this. Otherwise, what would happen? People would sue someone 50 years later for something that happened when they were younger, okay? So there's a lot of moving parts there, but that's why, similar to DWIs, you have to, once we get involved, we move very quickly. We don't look at deadlines. We just file things very, very quickly and move as fast as we can because there are so many deadlines.
Well, so for the employees, they're now learning this is what the process is for them. But one of the things that employees need to know, and I've had this conversation with clients, is, in fact, my last case in December, that jury trial, my client still worked at that place of business. Yeah. So there was ongoing stress and ongoing situation, even though the two managers in question were not in her store. Right. If people transferred to another store, she'd run into them at training. So sometimes employees have a job at another place, or they're without job, or they still have a job at the place where the harassment or the discrimination occurred. So let's talk a little bit about how we advise our clients and help them through that process.
Well, without question, once that complaint is made or the charge is filed or something like that, there is a target on their back. You know this, Kim. Target on their back. The employer, whether through managers or supervisors or otherwise, they are going to be looking to build a record to justify termination. That's what's going to happen.
And so, pressure cooker and stress on our clients, the employee, to live like that is really intense.
It's terrible. What do I do personally? I talked about a third of my time being this and this and this. I have a client who filed a charge, made a complaint, and is still employed there. And it's a horrible situation for anybody to be in. I think mental health is one of the greatest things that we have. I think that if anyone is having difficulty in that type of situation, or any situation in general, talking to a therapist or a counselor is one of the greatest things anyone can ever do. I've done it. I recommend that everyone does it. And so that's really important when they get into a difficult situation. For me, with that case that I currently have, and I'll explain why I don't have many of those, Kim, but for my current case where I have a still employed individual, I told her, I said, look, that's incredibly difficult. Here's my cell phone number. I'm not suggesting every attorney does that or even should do that, or that I do that with all my clients. I said, you're going through a real tough time. Hang in there with me, okay? I'm here to talk to you if you need a shoulder to cry on. If you just having a bad day, just call me, because I know that it's difficult. If an employee resigns because it gets that bad, Kim, you know this, the reality is it makes it really tough to proceed with that claim, because we're probably not going to be able to show all the evidence that went into why our client is feeling that way. We're going to do our best, but it may be difficult to show that. And then if they resigned, then it may cut off certain damages that they could have. And unless we can show a constructive discharge, which is a very, very high standard, it's basically, this is going to be deemed termination, even though you resigned, because this conduct was so horrible that no reasonable person could be expected to stay there. That's a really difficult burden. It just is.
So for the public, constructive discharge is basically you essentially you were fired, but you quit before you could get fired. They made it so bad for you, you had no choice but to quit. For example, an employee that has a shift type job, let's say at a restaurant, and all of a sudden they go from having all the dinners, you know, Tuesday through Sunday, and the lunches on Monday, and they have all the best slots for wait, you know, for wait staff, for tips and whatever. Then all of a sudden their shift is changed and all they have is, like, you know, Wednesday, Thursday breakfast. You know, if an employer wants to get rid of you, they're going to do certain things to make you miserable and to take money out of your pocketbook.
Right.
And that's constructive discharge, where you're like, I can't live like this.
It's where, and to put it in and that's a great real world example where the employer changes hours or changes pay or puts them in that situation because they know that because of childcare needs, because of the mortgage or the rent payment, that this person won't be able to continue here, and then they'll quit. And then we don't have to worry about unemployment. We don't have to worry about a lawsuit for wrongful termination or something like that. So a constructive discharge, in an even simpler term, is it's where someone quits their job, but the law is going to say they didn't quit their job. They were terminated because of your conduct, employer, and that's how we're going to view it.
Right.
So anyway, with all that said, just back real quick to your question, Kim, for somebody who's still employed, I don't take many cases where someone is still employed because it can create some problems. Now, you had a very incredible result as far as your case with someone who was employed, and there have been great results from it. My experience is that it can make it difficult. We only have so many hours we can dedicate to cases. And oftentimes, if someone is still employed, they really just want the situation better.
Yes.
And once we go and we file a charge of discrimination, it may set our client down this path that they don't want to be on, because it's going to make things worse. It's going to put the employer in a position of trying to make their job miserable, that sort of thing. I'm really careful about the cases that I take where someone's still employed. That's not to say that someone should not file a charge of discrimination or should not make a complaint or anything like that. I just, from my practice, I don't have, the vast majority of our clients have been terminated. But for kind of circling back around, the one or two that I occasionally have, I like to just be there for them and encourage them, hang in there, do your best, don't blow up on people. That's what they want you to do.
Right.
Rip on me if you need to. That's fine. But let's make sure that we hold them accountable, because what we know they're doing is wrong.
What's true for probably 99% of our clients, the employees, is that they don't necessarily want to sue. They're not looking
Right.
for money. They're looking for a safe place to work that helps them pay the bills and feed their kids, and they're not feeling bullied, and maybe the manager needs more training. In my case, that's what she even testified to. I just wanted to not feel terrible coming to, I didn't want to have an anxiety attack
Right.
before I walked in the door in my car trying to get to the store, which is what was happening to her. She was so anxious and literally had an anxiety attack that caused her to have to leave work one day because the stress was so palpable. But they want a better work environment. They want change, and they want probably their manager to have better training, because it's almost always an issue of, had the manager had training, they wouldn't be acting so foolishly.
Right.
And it's a corporation that doesn't care to make the life better of the employees, because they're just lazy sometimes.
Well, and that's what I was going to add with the manager training. Sometimes it's lack of training. It's also sometimes that the company just, they don't care all that much, because what contributes to profits more? You know this, when we try these cases, for the most part, there are some companies out there that care, right? But for companies that have shareholders to answer to, things like that, there's not a ton of genuine concern. That's why, as we talk about severance offers, the general public might think that, oh, it's because the company just had some goodness in their heart, and wanted to make sure that I was good for the next 2 to 4 weeks before I found a job. My experience has been that is rare. Severance offers they're on the spectrum somewhere between over here, where it's, we feel terrible we have to do this. We're going to pay you money because we're afraid of what this could mean to you. On the other end of the spectrum, it is, we think we've got some liability here, and it's going to be cheaper to pay everybody a little bit of money as severance than it is to defend a massive lawsuit when we create, because we're worried that we created liability. And Kim, my experience, I don't know what yours has been, but it's been that for severance, almost everything is here. as far as it's minimization of liability by a company. Okay.
Let's talk about that. You're an employee and your employer has offered you severance. What should you do? It should be in writing, first of all, but what should you do with the writing?
Immediately, because they're always going to be subject to a very short time frame. Okay. Contact a lawyer.
Yes.
All right. There are kind of two scenarios for me when I get contacted about a severance. First of all, we go into warp speed because we don't have much time to work with. Okay. We're going to take that severance offer and we're going to review it, start looking through it. What I tell individuals is based on a cursory review and what we learn of their situations. There's going to be a couple quick things, Kim. If it looks like this may be related to something illegal, such as a complaint that they made, discrimination, their age, something like that.
Essentially, if it looks like a payoff.
Exactly. Even if it's to a ton of people, we're going to look to figure out whether or not we think something squirrely is going on here. In that scenario, what I do, and all attorneys are different, is I say, here's what we're going to do. You've been offered $7,000 for your severance, okay? I'm going to represent you on a contingency fee basis. And I'm going to bet that I can get more money for you. I'm going to call the company immediately and tell them a couple things. One, I represent this man or this woman, and based on the research that I've done, and it's why we still dig through a lot of things, I think they may have a claim for this, whether it's an FMLA claim, a wage and hour claim, which is where someone's not paid for all the work that they do, or they're not paid time and a half if they work more than 40 hours a week. I said, however, I'm authorized to engage in some negotiation. You've offered $7,000, but I'm going to need this. And then the way I do it on those cases, Kim, I don't get paid anything other than a contingency fee portion of the amount that I recover over and above what's already on the table to my client, because I did not take part in them getting that offer. So I'm not taking a penny of that money. But if I can get them more money, then they're better off and we get paid for it. And I've had cases where we are not able to negotiate more. There's not that much, there's just no real liability. There's no reason for the company to pay more. And in that case, I don't get paid, but I tried my best for my client. And that's really all we can do.
Right. So an example is that they have a $7,000 severance. You approach the company and say, we feel you have some liability for X, Y, and Z reasons. In the negotiations, let's say you asked for $21,000 and they agreed to it.
Sure.
For easy math.
Yep.
Contingency is typically a lawyer takes a third. So you're talking about in your law firm, and every law firm is going to be different, so read your contract and ask a lot of questions, but a third would be 7,000 of the 21. You're saying for you just look at the 14.
Correct. Now, our contingency fee is higher, Kim, and that is because it relates to, there are attorneys who handle hundreds and hundreds and hundreds of cases. So we have a staff, and we limit our caseload to approximately, I would say 15 to 20 of these types of cases at most per attorney. Yeah. We spend a ton of time on these, and we push the thing. So our contingency fee is a little bit higher, but to get back, ignoring that correct. A lot of attorneys would say in that scenario, if it was at 1/3, for example, then some attorneys are going to either require money up front or bill hourly, or they say, we're going to take 1/3 of that 21,000. The way I do it is I don't believe that I had anything to do with getting that 7,000 on the table. I'm not taking a penny of it, but we're going to take a portion of the amount that we get over and above the 7,000. Because if somebody comes to me and they've been terminated, I don't want them ending up behind where they would have been had they not come to me. Not only is it bad business, but I have to sleep at night as well. So yeah, the other scenario, however, would be that when we analyze that thing, we look through it. If I say, look, I don't think there's a potential claim that we can make here. I don't think that there's any way to justify asking for more money. Then we'll do something like a few $100 and we'll review the contract, make sure the severance agreement, make sure that you understand it, answer any questions that you have, deal with any of those issues.
And that's more of a strategic consult. You're going to pay your lawyer to help you make sure that this severance is in your best interest, that you do accept it. And also because some of these severance agreements have limitations for your future job opportunities because they tell you can't compete.
They do. And with a severance offer, so Kim, I don't think we touched on this. What is a severance offer? Well, a severance offer is where a company, if we look at an individual employee, they say, we will give you this amount of money. We're going to fire you. We will give you this amount of money in exchange for you giving up essentially every right that you can possibly give up under the law. There are certain rights that cannot be given up. But if you think you have a sexual harassment claim or retaliation claim, you're waiving that thing with that severance. And that's where, when we do the severance negotiation, I go to the company and I say, well, you have a choice. I mean, we can either negotiate now, or I'm getting ready to file a charge of discrimination on behalf of my client. And let's see what happens.
And sometimes it works out for the client, and other times they really don't have a claim. So
right. And when people come to me, even if they don't have a claim, or we're not able to, if I jump in and I try to negotiate, the company won't pay more money, I'll be honest with my client. I don't recommend that you proceed with a charge of discrimination, because our likelihood of success is going to be very, very low.
right.
It's probably not something I would even feel comfortable going for. I make sure my clients understand all their rights. I don't tell them what to do. I tell them pros and cons, and I know you're the same way, and what my thoughts are. And I think that's why I have a good relationship and a good trust with my clients, is I'm just going to shoot straight and be honest and give them my thoughts, but I'm going to follow their wishes. We always have to. But in that scenario, sometimes it doesn't make sense to file a charge, and maybe we don't get paid on that case. Maybe we spent some time, away from our family or away from other cases working on this thing, but that's just part of what we do.
Yeah. Well, John, we're here at the end.
Okay.
Just a couple points for any final thoughts or words that you want the public to know about, because this is an informational video. And obviously we have stressed over and over and over, if you feel you're being discriminated against, talk to a lawyer. If you've been offered a severance package, talk to a lawyer. If you just don't know what to do because you hate your job and it's really going badly and you don't know if you have any rights, talk to a lawyer.
Yeah, the one thing, Kim, if I can add just real quick, I'm not providing any opinion as to what other attorneys may do as far as charging money. What I'll tell you is this. My reputation speaks for itself. My results speak for itself. It's the exact same for you and the exact same for a lot of attorneys, otherwise that may handle these types of cases. If an individual comes to me, it's a free consultation. I know that's the case for most. I will say this, generally speaking, most other lawyers that I know throughout the state, throughout the country, who handle a lot of these cases at a very high level, we do not charge for consultation. It's free.
Right.
We're also not going to charge you some flat fee or hourly rate. That may be the only option for some people, but I'll tell you, make phone calls fast, and get in with an attorney, and one that's going to do it for free, because you're better off, before you go that route of some attorney said, well, I'll do it, I need a $5,000 retainer, or give me a $3,000 flat fee to do a charge of discrimination. You've got some attorneys like Kim Benjamin, who is absolutely fantastic, tons of other attorneys. I like to think that we do well for our clients. Thanks, Kim. We're going to do that for free. We're going to give you our thoughts. We're going to analyze the case. We're going to gather that information. So that's something that's important. The other thing that I want to add that maybe we didn't touch on, if you think you're being subject to discrimination or retaliation or anything like that, document everything, okay? Document everything. And Kim, you know this, here in Missouri, if I'm having a conversation, if we're sitting across from each other in a room, and let's pretend we're not attorneys and there's nothing going on there, but you're my coworker, I have a right under Missouri law to, with my cell phone, go ahead and record that conversation. Even though the other party doesn't know about that conversation, as long as I am a party to that conversation and I know that I'm recording it, I can do that in Missouri. Now be careful, don't do that over the phone, because if someone is in a different state, it could create issues that could get you in trouble. But if you're in Missouri and you're having a conversation with your employer or coworker or something like that, you have the right to record that. Just be careful disclosing that, because it does seem a little bad if you're recording conversations. But that can be our choice as to what we disclose and not disclose, and at what time it's going to be required to do so. So the biggest thing is gather evidence, keep emails. When somebody makes a statement to you or anything, document who the witnesses are, when it occurred, where it occurred, things like that. And that's going to be helpful in the event that this has to move forward, if nothing else, to help refresh your memory since you recorded it.
And I want to say something about recording, because in my last case, in December, the jury trial, one of the reasons the jury gave such a huge punitive damage verdict, which was $1 million, was because the manager, after getting a letter of representation from counsel of save all your documents, we're going to proceed with the case, right? The manager goes into a private room with the assistant manager and the employee who complained, who now has a lawyer, and secretly records the meeting, which was absolutely lawful.
Right.
However, the company had to give that over to us because the manager gave it to the company. And in discovery, we got the recording, and it was so obviously a very abusive meeting to, bash the employee without mentioning the fact that she had a lawyer, but mentioning the complaints and like, why don't you like me? And I'm not bullying you. I'm here for you. And all this fake stuff was going on in it. So you have to be careful when you secretly
100%.
record something, it might get disclosed. And so secretly recording something is something, in my opinion, that you talk to your lawyer about first.
And I just wanted to say that individuals, and I'm sorry for talking over you, Kim, individuals have a right to do things and they should document things. When I say that, it's because, and you're 100% right, I knew you were going there, it can be a double-edged sword. Because if it appears that an employee, for example, on this side, if it appears that an employee was trying to record a conversation to try to set the employer up for something and get them to admit something, then a jury, which juries can do a lot of things. We presume that they follow the law. We have to trust that they did. And that's, how it operates. But juries usually fixate on different things than what we as lawyers might even believe that they could. And that's something that has always concerned me as well. So when we get retained, my client does not record anything without talking to me. And it's not going to be anything of you're going into a meeting and you're getting set up, or that you're going into a meeting and you're going to try to set up the employer or something.
Right. It's one thing if I call them as the employee, if I call a meeting with my manager and then start saying, remember that time you did X, Y, and Z, and I'm trying to get them to confess on tape, those are problematic. But if the employer says, we're going to do your quarterly review and you want to record that because you know that they're going to be abusive to you, then record it.
Great example, Kim.
The employer says, we're going to have a team meeting, and you know that these team meetings, they do very inappropriate things that could be sexual harassment or age discrimination, whatever it is, secretly record the team meeting.
And Kim, I'll tell you personally for our practice, when I talk to my clients and we let them know that, I advise my clients not to record, as we talk about, anything unless I'm aware of it. And I'll tell you, in the last handful of years, the only times I can think about a client recording something with my knowledge that they were going to go do something like that has been where they're getting called into a meeting. That they're getting called and we know what's happening. And it's just, we want to make sure that this piece of information is preserved. Basically, the employee is going to be sitting there listening to some things they don't want to hear. They're not really going to have much else to say. It's going to be a termination meeting or something like that. And we don't want the employer to come back and lie about what happened. So I 100% agree that I tell my clients, do not record something if you're going to try to set somebody up. Absolutely not. And I don't even like it, but I think it just stresses the importance that we want to document things, emails, texts, stuff like that.
Right. Document and save the emails, maybe your personnel file. If you know something's coming and you're not going to get access to your personnel file, maybe, whatever you can get your hands on, but also journaling events so that you have the names of who was present, the events that occurred on this day, the circumstances around it. But also these things can, like a journal entry, for example, a journal could end up being evidence at trial. So your journal should not also be your journal about how much you love your husband or hate your husband or your children, right? You just focused on work.
The only caveat with that, Kim, would be as far as screenshots and emails and things like that. Remember that all of that, particularly on company systems and computers and things like that, that may be the property of the company, and it may be proprietary, secret trade information and protected. And So we need to be careful, and where I have, usually when I'm talking about my client documenting things, it is more of text messages, communications, things like that, because we want to be very, very careful that we're not violating the rights of the company either. And so when it comes, when somebody comes to us, this is all part of an even bigger conversation that I have with my clients of, let's talk about what's going on and let's talk about what rights you have. And that's why it's important to get a lawyer involved and get a good lawyer who does this area of law primarily involved, is to be able to talk about what you need to record, things like that. What I've done in the past, Kim, and I know we got to wrap this up, but what I've done in the past is make sure that my client, if she's seen something, just take some notes as to what sorts of search terms we need to include in our discovery requests, such that it's going to pop up those documents. When to look for them, what dates, and here's what to search for. And that's a way that we've been able to uncover documents that probably wouldn't have been disclosed by the company on their own.
So for example, if an employee has an email exchange with someone and that's going to be evidence that they feel of discrimination in that email, it doesn't hurt to forward that email that you are a party to your personal email and get it into your Gmail account, that whole string. It
could be a problem. And that's why it's important to have a lawyer, because if, for example, I have, and I've represented probably every walk of life, every industry, but we want to be careful, because if there's something that prohibits an employee from disclosing, the craziest example I could give you, Kim, would be this, and I've never seen it, but let's say, for example, you're a federal government contractor with high security clearance, and just because you get an email that you think is evidence if you were to bring a lawsuit, if you were to send that to your personal account or you were to print it off or something like that, we're going to have some problems. Now, that's the extreme example.
Right, because that's a terminable offense for someone most likely in that situation.
Exactly, but that's what we have to do.
Even printing it would be a problem.
Yeah, you're exactly right. And so that's where we as lawyers come in, is to help guide our clients on what they can and cannot do. You know this, I love the legal profession, but there are bad apples just like there are everywhere. And I think that they get weeded out through the process, just like my father's a physician, just like doctors and anybody else. But for the most part, we're ethical, but occasionally certain things happen to where lawyers may be gathering evidence or whatever. Look, that's just not the way I do it. I learned from my mentor when I was younger, in first getting into law, if you can't win with the facts, you don't deserve to win. And you got to do things the right way. And Kim, you know this, there is a right way for us to do that and get that information. What we don't want to do is allow our client to be put in a bad situation for litigation purposes because we didn't properly advise them on what to protect, how to protect it, if they can protect it in that manner. And we know ways to go after things. So it's really different ends of the spectrum on industries and what we can and cannot do, and what obligations and fiduciary responsibility an employee has to their employer. We keep talking about all this, and it's not for the sake of telling someone, hey, call me, call Kim, we'll be great. It's to say there is a very valuable role that an attorney plays in this from start to finish. And that's what we're here for, and hopefully educating people with enough to understand what their rights are, courage to know that they're protected, and that there are resources here for you, that you're not going to have to pay tons of money to get access to an attorney.
That is the perfect ending. Access to justice, courage to ask the right questions and know your rights, and there are resources for you, and it's not going to break the bank because you're going to get access to justice in a situation like this.
Absolutely.
Excellent. John, thank you so much.
Thank you, Kim. It's great talking to you.
And we talk all the time about trying a case together. It will happen. COVID has stopped us from trying cases right now. But somewhere in 2021 or 2022, we're going to try a case together.
We'll get there sometime. I will tell you this, and I know you see the same thing, is when you do the things the way that you and I do them, I can't buy a trial. But that's to our client's benefit. But we do things the right way. We'll get there, Kim. It's just, shoot, let's keep getting good results, and we'll try one soon. I'll call you.
All right, John. Have a great weekend. Thank you.
You too. Be safe, Kim. Bye.
Okay.